Ready? The original plaintiff, who is a agricultural officer, is not satisfied with the judgment dated 27th March 2010, delivered in regular civil suit number 55 2007, whereby his suit came to be dismissed, has preferred the instant appeal prayed to set aside the impugned judgment and decree his suit. Para. The relevant facts which gave rise to initiate this proceeding runs as follows. For the sake of brevity, the parties are being addressed as plaintiff and defendants. The plaintiff hails from Mahagaon, is a BSc Agri graduate. After completing his education, he had started Agro Service Center at Mahagaon under the scheme of Government of Maharashtra, but is not succeeded. In the year 1982, he got a government service as an agricultural supervisor. As he had no residential plot or house at Mahagaon, had applied for the same wide revenue case number 1 oblique LNA oblique 22 oblique 1980 81 and plot bearing number 140, area 135 square meter was granted to him. To that effect, the certificate was issued by Tahsildar Mahagaon. Due to his job, he had not created permanent structure but had erected a temporary compound wall, but same was removed by local person behind his back. He had also dug a well in said plot. Said plot has been described in para 2 of the plaint thereafter referred as a shoot plot. Para. Surprisingly, he came to know that in the month of 2007, dependent numbers 2 and 3 have published a proclamation for auction his shoot plot. The copy of that proclamation was affixed on the board of Gram Panchayat. In result, he approached to the dependent number 3, to whom requested to supply the certified copy of entire proceeding of proclamation, but did not get the response. He got a rough receipt dated 3 March 2008 from dependent number 3. The dependent number 3 is interesting to allot shoot plot to third party. As there was no alternative, he approached to the learned trial court and initiated regular civil suit number 55 2007 by seeking a decree that the auction taken by the defendants number 2 and 3 in regard shoot plot is not legal and binding upon him. He also sought injunction. Para. The defendant number 2 put up the written statement exhibit 16th, which is adopted by defendant number 1 and 3, while pursues exhibit 31, wherein they denied the allegation put up by plaintiff. In addition, averred that in the year 1997-78, shoot plot was allotted to the plaintiff by defendant number 2 under certain conditions, but he failed to make any construction over shoot plot within the prescribed time. Therefore, in the year 1990, the defendant number 3 initiated the proceeding in respect of breach of conditions. In the year 1992, the concerned Talati made an inquiry, put up his report about non-construction. Thereafter, he concerned Naib Tahsildar had called the report of Talati, and accordingly on 20th November 1995, Talati submitted his report to the defendant number 2. Thereafter, the permission from sub-divisional officer was obtained and the defendant number 2 forfeited and auctioned the plot. Thus, the defendant has not committed an illegal act. In fact, the plaintiff is not in possession as the auction is taken place on 26 February 2007. Para. The learned trial court has framed the issues at Exhibit 30 after providing an opportunity to both the sides. Conclusion is that plaintiff is not the owner as well as in possession of the suit came to be dismissed on 27th March 2010. Para. The plaintiff appellant raised a ground that the learned trial court has not appreciated the evidence in prospective manner. No evidence has been adduced by the defendants. The learned trial court ought to have been decreed a suit, but it is not done so.